Maybe before I get to my prepared remarks, I'll just say a couple of things beforehand. We're kind of connecting yesterday to today. It's not so much a separate lecture as a continuation or a more granular look at some particulars related to this problem that I first identified yesterday. I understand that some folks were having some doubts about the reality of some of the things that are being explored within the techno-scientific community. Which is, I suppose, a reasonable position to be taking. Surely that cannot be going on. Now, of course, the point I was registering was not that all of these things now being explored are feasible projects. Remember, my first point was a critique of the technological philosophy, the way of looking at the world as simple measurability. What is here, what we know about it is what we can do with it. There are no other standards that would restrict how we engage with the created order, except for what is technically possible. And this is why I was raising the illustrations about the attempts to tease sperm cells or egg cells out of skin cells in order to overcome what appears to be the immovable requirement of a mother and a father for a child to appear in the world. The bodyoids proposal is not because they've already accomplished that outcome. It's rather that they're making very plain that this is an aspiration that they would like to see realized. And some of our most prominent research institutions are devoting themselves to thinking through how they might accomplish this thing. You follow? Those of you who are interested in citations to different articles that are discussing these things, find me or get in touch with Dr. Edwards. I'll make sure he has some of the links if you want to follow up further. Very good. Okay, on then to my prepared remarks. In the various classes that I teach, I maintain a theme that the law's many and vital contributions to the peace and proper ordering are necessary to human community. It is justice, along with the law and the institutions that carefully ensure it, that represent and sustain the natural habitat of human community and existence. As such, its maintenance is vital, its loss a calamity. It is to one aspect of that calamity that I'll be giving attention in my remarks today, following on by way of application of yesterday's presentation on the technological philosophy that is turned back upon mankind himself, with devastation both on persons and on the law. That is, to the operation and significance of what I've been calling in recent venues machine anti-humanism. For the last few years, the British writer Paul Kingsnorth has been offering his stern rebuke to the contemporary designs of social organization in terms of its domination by what he calls the machine, a term he borrowed from Lewis Mumford. And his use of that term being what inspired my own use here, Kingsnorth decries the profanity of the technium, which we seemingly cannot escape because it has become the world in which and through which we live. Recall yesterday's mention of C.S. Lewis's observation that now man himself is the business of science. As I also set out yesterday from a troublingly long list of illustrations, we could mention of the man as machine for tinkering with model is the eugenics crusade that was flourishing in the early 20th century and now is back among us with a vengeance. This includes the CRISPR embryo editing technology that I alluded to, the transgender upheavalism, whatever we ought to call the lawless ghastliness visited upon us during the COVID epoch, and of course the child manufacture industry, to which I'll be giving particular attention in my remarks today. Whether the world is considered blank stuff to be manipulated and assigned meaning through a subjective projection of technological or technocratic will upon it, or is a creation of meaningful and telos-endowed order, is at the heart of our contemporary disputes and crisis. Here we might helpfully consider, for illustrative purposes, the purported right to abortion. This putative right having over a half-century of operation upon national consciousness in my own country, has correspondingly reorganized the cultural order writ large there, and thus has subverted law in multiple dimensions. It proposes that pregnant women are in non-relation to the eminently inconvenient and technologically disposable fetal presence within them, and as a result, these women are free of responsibility to it. Whether a relation and a responsibility later comes into being between mother and child is attributable to the mother's choice and intent, not because of a pre-existing embodied truth. That is, the United States Supreme Court cases and other policy enactments, just as I gather more recent and comparable rules and policy here in the UK, have made official the conversion of motherhood from a natural and public fact to a private choice, thereby relocating the meaning and relationality of human persons from immutable nature to flexible option. The family, visibly represented in vital respect by mother and child, therefore is not a reality of creation or a primal aspect and expression of human identity, but it is a construct of selection, thus ultimately subservient to the state agencies that authorize and oversee those individual choices. My concern here, in short, and that I will now be discussing, is with the justice of the family and the difficulties attending the contemporary moves in law that would drain human nature of its familial relational significance or its givenness at all. As I began my comments yesterday, the contest over the human question, who and what we are, is in sharper focus now more than ever, in ways that I think verily beg for careful study, discussion, and conference in education venues like this, as well as in the wider context of community gathering. The contemporary legal order, as it addresses the family, is trending towards standards and defining precepts that deny or refuse roots, nature, or limits of any kind, embodied or otherwise, classifying these to be normatively irrelevant, personally inconvenient, and in all events, impediments to be technologically overcome rather than contemplated, honored, and lived in. Those of you with the misfortune of following social media daring do, or in my case, if you receive emails from people who are, you may have encountered pictures like the one I'm about to mention. This photo sent to me was posted on social media by a male celebrity showing him and his male partner together shirtless in a hospital room holding a newborn infant, which they had purchased and procured by the government-approved mechanisms of human trafficking. In their case, this involved purchased ova, a lab-manufactured child made to be motherless, and then surrogate gestated and snatched from her after birth for their possession. It is, as you presumably know, now in fashion to enlist technicians to design and produce to specification a helpless child as an accoutrement of adult lifestyle wish. This process is enabled by the moral illiteracy into which we've been collectively tutored by, in no small part, officialdom in the Western world, as it has subverted the law in order to empower and advance the sexual revolution. Indeed, courts and legislatures across the land have ratified the making and custodial possession of children through contractual technological means in which maternal and paternal filial relation to the child is deemed meaningless in order to accommodate and authorize child acquisition by same-sex couples or thruples, or anyone else for that matter, whose relationship, lack of relationship, or simple whim may prod them to engage the techno-commercial enterprise of child production. The prevailing idea is that courts have ruled this sort of child distribution regime being implied in and required by the legal imposition of a new gay paradigm of family. I understand in the UK there's a similar outcome, though more heavily regulated, through the direction of the Human Fertilization and Embryology Authority. Though that paradigm that I mentioned has long been operational in law and other forms of cultural prominence for many decades, its uber conquest has been ensured by the fantastical insurrection called same-sex marriage, posing as a fundamental right commanding legal recognition. While the Supreme Court in my country, its version of this imposition of upheaval upon the country, in it the court ruling appears limited to simply declaring a right of equal access to a state marriage license for same-sex couples. But the court's ruling, along with its written explanation, implied and arguably sought to prepare further innovations in the legal recognition and public definition of family relationships, and thus of human meaning itself. Indeed, since the ruling, scholars and advocates have urged, and courts and legislatures have advanced, the alteration of what the family is in a way that disqualifies the law's venerable acknowledgments of natural relationships and their given authority. In short, the legal inversion of marriage has dramatically accelerated the unraveling of the anthropological commitments that have grounded innumerable aspects of our venerable legal system and the rule of law itself. Not only have courts and legislatures feigned to redefine civil marriage, they've done so on the putative basis that the exclusive husband-wife standard is an exemplar of injustice, a source of humiliation, dehumanization, and dignity denial to same-sex couples and their households. One could wonder then, on such an account, how long will endure the legal standards that depend for their justification on the unique authority and value of the complementary relation of male and female, of mother and father, that is now officially deemed an intolerable baseline for family law. And sure enough, in the 2017 ruling, serving as a triumph of techno-affirming policymaking, the United States Supreme Court, 2 years after its civil marriage redefinition ruling, decided that its marriage ruling and opinion are to be read as requiring a state to put the names of 2 women with a state marriage license on a child's original birth certificate as the parents in the place on the certificate providing for the child's mother and father. For a court classified the content of birth records, birth certificates, and impliedly classified the children themselves as a benefit that the state gives to adults who are licensed as civilly married. And this is a viable proposal now that children are lab-made via purchased gametes rather than through the conjugal act. This effectively erases the office of father from a place of relational and legal consequence whenever convenience would dictate. In similar vein, a number of states around my country have made legislative revisions to family law standards in the name of equity, fairness, and inclusion, which apparently means universal child access. For instance, the state of Massachusetts at the end of last year enacted a Parentage Equality Act that makes the category of parent a disembodied one, encompassing adults who possess the intent to hold that custodial position over a purchased and technologically delivered child. That mental disposition on the matter is, of course, androgynous, unrelated to procreation, and so the Massachusetts Act scrubbed from locations throughout the state family law code the words mother, father, he, she, his, her. With the removal of these words comes likewise the removal of the concepts that those words hold. That is to say, this is the evacuation of human nature from law. Warming to my subject then, and the particulars of my machine anti-humanism indictment and written project from which I'll now draw. My dissident thesis in objection to all of this is as follows. Basic to the law's role in the relational security of children is the law's deference to the natural family and the anthropological depths that this family represents and anchors in society. Contrary to the precepts and machinations of the multi-billion-dollar global child manufacture industry, a child's entry into existence is not as a blank, solitary integer, primordially unaffiliated and just as well distributed for upbringing to any one household as another. To the contrary, children are, in and from their conception, radically relational and immediately and naturally connected to their forebears. Throughout life, children will express in their visibility the bond and resemblances with their mother and father from whom they sprang and to whom they are indelibly connected and thus presumptively received and cared for in their vulnerability. To paraphrase Gerard Bradley, children are the marriage. D.C. Schindler has penned an evocative phrase that describes the richly normative and revelatory character of creation, writing that it is meaning made tangible. I think this is especially manifest with children whose lineage, kinship, their family is inscribed in their very features. The recognition that a child has an identity bound up in hereditary descent and that the mother-father-child triad is a profundity central to the human condition, therefore meriting unique deference in the law, has been a constant throughout human history. The organic and natural fact of the human person as familial is an orienting and ordering consideration of justice itself. For it is the calling of the law and the ground of its authority to say what is true about the human person. And that understanding of person then guides its entire structure of standards. Yet throughout the Western world today, we find ourselves in a new and troubling condition of seeing our governments and other institutions of influence, in defiance of all human history, redefine marriage and family relations, reconfiguring them in service of a denatured, individualistic, technologically reductionistic, and ultimately statist alternative. And among the questions now upon us, in uncomfortably clarifying ways, is whether a child in fact belongs and has a claim to the mother and father from whom he sprang. The assisted reproductive technology, or ART, industry, with its picture catalogs of men and women whose gametes are for sale, its lab creation of batches of embryos for eugenic sorting, its gestate and release surrogacy contracts, all of this exists to decouple child creation from conjugal relation, to segregate gestation from enduring maternal relationship, and to make blood ties irrelevant to legal child custody and identity. The disintegration and fragmentation of persons, parts, and relations, and to subject all of them to commercial negotiation, is the entrepreneurial essence and audacity of this technological regime performing a redefinition of human nature. In terms of its biotechnocratic and consumerist framework, the child comes into the world not naturally related to anyone, but only transactionally connected to persons responsible for summoning him through purchase or technique or other effort that the law may ratify. When the law permits and coordinates this commerce in persons, it teaches and ensures that the existence of a child is a legal problem for state resolution, rather than a pre-existing relational truth to which the state must defer and then honor and protect. Moreover, for the law to discard the truth of the humanly defining relationality of the child to his forebears, in turn deprives law and society of the public premises that make it possible, for instance, to recognize and mourn the pitiable plight of orphans, to know that adoption mitigates a grievous loss, to justly condemn deadbeat dads, and otherwise to recognize a beauty and responsibility of care and support by a father and mother in view of their generative relation to their child. Each of the foregoing concerns is sensible only if the child is, ab initio, in a fixed relation that carries meaning and duties. But the new legal model on offer proceeds by describing the child instead as a raw datum, ontologically isolated and absolutely individual, without a history and without a certain home, until the happenstance of a managerial adult choice intervenes. This sort of mechanical, contractual, and gender-neutral redesign of humanity invites a totalitarian political dynamic. For if the law now refuses to defer and conform uniquely to the authority registered in the natural family and its filial bonds, and instead redefines marriage and parent, and perhaps even male and female, to assign rigid equivalence and status to persons and relations that are, in fact, profoundly different, then a pristine legal positivism is enacted in which any sphere beyond state construction and command effectively disappears. When the individual is loosed from the natural family and its constraining certainty of relatedness, he, along with his now contingent relationships, is instead comprehended exclusively within the uncertainties of political solicitude. Thus, though this family redefinition is carried out under the banner of reproductive and sexual rights, instead of accomplishing a limitation on government power, it becomes an instrument securing, in principle, the totalism of state jurisdiction. For on this account, parents are deemed provisionally accredited custodians, not naturally vested authorities. As on this telling of things, bodies are but mechanisms with the locus of personal identity present in subjective, invisible interiority, the embodied connection of husband and wife, mother and child, father and child, are only empirical or mechanical, not meaningful and personally or humanly defining. Thus, the family, that natural community and symbol of integration, is being redesigned in law to conform to the precepts of disintegration, marking our era. The law is explicitly adopting a mechanistic philosophical outlook as it cooperates with public and prominent biotechnical practices that implement that perspective. These include, as I described earlier, the pharmaceutical and surgical elimination of children in utero, because on this account, recall, there is no normative meaning or responsibility implied in maternity when seen in exclusively biological or technological terms, as well as the manufacturing model of human reproduction by consumer selection. So to that we now turn. In the disintegration of the former integrating and humanly explanatory institution of the natural family, the global baby, so-called, represents the paradigm and the central case of the industry, precisely because it best symbolizes the disintegration of nature and organism that is accomplished by the ART project. This infant manufacture regimen represents and enables the abolition of relationality in reproduction and custody. And with that, it establishes the irrelevance of the location of the gametic, gestational, technical, and financial participants in this endeavor. The so-called sperm donor may live in Israel, the ovum contributor in Italy, the gestator in Kiev, none speaking the same language, and the only one to lay eyes on the child is the customer in Liverpool who placed the order and flew in to pick it up. Classifying all aspects of reproduction in mere functional terms enables their commercialization, thereby qualifying them for offshoring and otherwise participating in the efficiencies and larger genetic and physiological resources of global markets. Liquid nitrogen freezers, air transportation, and information technology make geographic divides of no production consequence. And because the ART baby is a project of making, it veritably demands the law to apply a consumer paradigm in the later custody determination. The person hiring and directing the technicians to manipulate the biological material is the one that should receive the tailored product of his commissioning. This is called parenthood by intent that replaces motherhood or fatherhood by nature. By permitting this technician-engineered form of reproduction, the law's own description of human meaning is on track to correspond to the mechanical features of this system. Once the law permits this will-based technological biotech making of children from the part and the efforts of dispersed participants, the law already takes for granted and validates that the child, despite the visible realities of genealogy and family origination, in fact belongs to no one in particular. Moreover, the law thereby abandons the grounding for its historic authority and practice to enforce maternal and paternal duties and claims that are grounded in the ontology, authority, and moral command of those relational offices that are embodied. The ART industry's coup, then, is not merely in the mechanical accomplishment of human reproduction, but in capturing the standards of the law itself. The law's failure to forbid at the front end the industrializing of human reproduction ensures the law's submission thereafter to the mechanistic or technological premises of that project. For the ART regime is not just advocating for an unnatural anthropology. It produces vulnerable infants requiring resolution of their custodial placement, which demands the law's participation. And with that participation, alas, comes the law's validation of the deeds that it inspects and then honors with rules fitted to their character. By pressure of the novel circumstance now before them, judges or other state officers are essentially compelled to stipulate a legal principle elevating something other than the natural integrated whole of maternity and paternity as the ground for the law's determination of an adult's custodial claim and duty to a child. Whatever the contrived resolution in the law, the adjudicative task has been subordinated to the circumstance of industrial reproduction that the law has permitted and whose human products the law now confronts and must situate. The end result of which is that the family as such now sits in a precarious position. While its historic authority and prerogative are still acknowledged by many, its objectivity and authority is denied in our elite precincts and corridors of power for being insensible to the machinic logic that has divorced itself from the humane thought forms of Christian civilization. To conclude, the machinism of the techno-reproduction of children that is adjacent to redefined civil marriage and other profanities is more than just morally daft. It is a mutiny against creation. It is a revolution against the real. It is a boulevard into ruin. The reasons to refuse its terms are compelling and numerous, not least of these being the matter of communal existential self-defense. That such stakes are finally coming into view makes plain the matured social authority and viciousness of sexual freedom dogmas that have authorized and facilitated the industries foisting their technological powers back upon the human body, now deemed nothing but material for purchased manipulation. When these dogmas and corresponding legal changes were introduced to us, they were advertised as being merely marginal adjustments in the interests of civil rights. Carefully obscured was their ambition and meaning, which is total upheaval. We now have the benefit of seeing that more clearly. Thank you.